Welcome to today's webinar. My name is Ilka Hartmann. I'm the Managing Director of the British Chamber of Commerce in Germany, and I'm very happy that we could do this jointly together with our BCC in the Netherlands, in Belgium, and in the UK. I'm very happy to have such an elaborate audience and great experts who will tell us about corporate migration post-Brexit. And I just hand over to Hugo from the Netherlands Chamber to give us some insight, and then the others to say some welcome, and then we'll start right into the webinar. Enjoy.
Thank you, Ilka. Thank you very much for that lovely introduction. And yeah, I'd like to also welcome everybody, of course, to today's event. I'm from PwC, working together a lot with the MBCC in the Netherlands, especially on Brexit issues, obviously. I myself am specialized in people mobility, and Brexit's one of my own personal pet topics. So that's why I'm often involved in these kind of things as well. Now, I don't think I need to tell anybody in this likely very knowledgeable audience that Brexit has, of course, had an impact on people mobility, and things are not the same as they were before, quite clearly. And basically, it's just no longer a question of hopping on a plane from Amsterdam to London, for example, and going for a job interview or starting work or anything like that. There's big changes. And one of the big dates, obviously, is the 1st of January. I think what we're most interested in looking at is what the impact is for people traveling after the 1st of January, those who have no rights under the withdrawal agreement and who are then facing new immigration rules, immigration restrictions. And in that sense, of course, we did expect some issues which did arise with some individuals, for instance, being questioned at the border around the beginning of January, whether they were allowed to enter or not. We've also seen in recent weeks some EU nationals being stopped at the border in the UK.
Hugo, je staat op mute. You are on mute.
Okay, did I remute? Or
yes, so. Go ahead.
Go ahead. Did you hear anything I said before or not?
Yes, you can just continue.
Okay, I'll just basically continue. Thank you very much. All right. I hope I've not popped on mute again. Let me know if I do. But basically we can see that the pandemic obviously has limited migration that we would have expected were it not for that fact. And I think we've seen obviously that then the impact of Brexit has therefore been delayed. And we can see that very clearly from the personal situation. Of course, we're doing this virtually as well. And we of course very much like to do that in person. And in that sense, we can see now that borders are slowly reopening, there's a slight increase in optimism. We can see that people might be expecting to work remotely much more, but that might be a bit limited in the future. And in that sense, obviously, there's a big question mark around what type of mobility can still be expected between the UK and the EU. But what makes the timing of this specific event actually really interesting for me, and what I'm really interested in, is the labour shortages that we've been seeing in the media quite recently. So especially on the UK side, in the services and retail sectors, in the agricultural sector, so for seasonal workers, but also in the food industry or in haulage and supply chains, we've seen a big impact where basically EU nationals who filled positions in the UK are no longer doing that. And that's a combination of Brexit, whereby people travelling after the 1st of January don't simply have the right to work. On the other hand, obviously, the pandemic, where EU nationals went back home and have not returned. So in that sense, I'm really interested to see what our experts have to say here today. And obviously, it's a very, very current thing. Actually, I know that JZ Flowers International is being interviewed during a current affairs program in the Netherlands called Newsviewer tomorrow. So I'm very interested to see that. And obviously, we've been connecting with other members of the MBCC and other networks to see where we can sort of support them and basically see what's going to be happening for the future. Keeping it short, I wouldn't want to wait too long before handing over. But basically what we've been seeing ourselves is that as we're exiting the kind of Brexit and the pandemic period, a company should be looking towards the longer term. But Brexit now, especially in the UK, is forcing some companies to look slightly more short term again, which might be a little bit frustrating, but I'm very interested to see what particular countries have going on and see what insights we have to help companies, of course, navigate the complexities of Brexit. So without much further ado, and hopefully I've not muted again in the meantime, I'm going to hand over to Daniel Dalton.
Thank you very much, Hugo, and welcome from Brussels. We're delighted to be involved in this together with the German and the Dutch Chamber, and thank you, Ilka, for putting it together. I think I'd just echo everything Hugo's just said. I mean, we're seeing similar problems, but the key question for us going forward is what's going to happen once travel restrictions are lifted and people are trying to come for short-term work. So, for example, consultants coming over to do 1 or 2 days work in different EU member states. And from our side, we're quite worried about what's going to happen here because obviously there's, as we'll find out today from our experts, exactly what's covering a lot of these issues. But we can see that there's a lot of uncertainty and it's very much not clear for businesses, and even businesses in the UK, quite big businesses in the UK have said to me that their workers can work in Europe for 90 days, which is not the case. So we're very happy to be part of this. We think it's a key issue going forward, and we're very much looking forward to what our experts have got to say. Thank you again, Ilka, for organising it. I think, do I need to pass on to Anne-Marie now? So that's right, Anne-Marie, over to you.
Thanks, Dan. I'll make it very short and sweet. So hello, everyone, from a very weird weathered London today. We've had rain, we've had serious thunderstorms, and we've had quite a lot of sunshine as well. So very strange. Delighted to be here. Thank you very much, Ilka, for organising, and to others. It's great to see, as British Chambers of Commerce, which is the sort of umbrella of British chambers across the world and the UK, to see some of our members coming together. It's fantastic, 3 members today to organise an event like this, which is really relevant for the entire business community that we represent. So looking forward to hearing more from the experts. And I'm not sure who I am handing over to, but I'm sure Ilka would tell me.
I'm taking it back, Anne-Marie. Thank you very much. And, now the experts should talk, and I turn over to Mr. Mavers and his colleagues who will guide us through the webinar. If you have any questions, you might as well start writing your questions in the chat so we can cover as many questions as possible. If you want to speak up personally, raise your hand so we see that you want to say something in person. Mr. Mavers, the floor is yours.
Yes, thank you very much. And different as it is shown right at the bottom of my screen, my name is Gunther Mavers and not Marta. Marta is our lovely daughter who has been in possession of that iPad I now am using for the last 12 months, I guess. And my laptop crashed down. I couldn't use it. Sorry about that. Firstly, thank you very much to British Chambers of Commerce in all countries represented here. It's a real pleasure to have you all aboard, and thank you also for setting the scene with your introductory remarks. We are really delighted to see how much interest the topic has raised, and that goes in particular for the participants who have volunteered to help me out here to speak on behalf of the various countries represented on the panel. That is Laura Devine from the UK in London, Barbara Wegelin in the Netherlands, Stefan Collot in France, and Bernard Caris in Belgium. We are all friends now for many, many years. And earlier today, in preparation for that meeting and session, Laura asked me over email, well, what would you like me to ask you if we have time left at the end? And I was telling her, well, you may ask me, what are the privileges that are left for the UK nationals in Germany post-Brexit? And she was saying, well, that is a very sad question. And that indeed is right. Finally, Brexit has happened. We have all, I guess, at least all been hoping for that not to happen. I personally have had well, I shouldn't say the pleasure, but I have been in London on the day of the referendum. I was hoping for a backturn the next couple of years, but finally nothing helped. The withdrawal agreement has expired by the end of last year, and another deadline expired by the end of June if it's not extended. So we now have to face reality and have to see what are the rights with UK nationals in continental Europe post-Brexit, and also the other way around. And to make this as interactive as possible, we have chosen to come up with two little hypothetical cases. Laura, if you could share your screen maybe in a minute, that would be great. And at any time, you, the audience, may of course put questions and interfere as much as you like. Because it's more important for us to deal with your questions rather than to go only to these cases. At the end, we do hope to have many, many answers for you, but I've heard the word uncertainty earlier, and I'm fearing that many, many questions will remain open, but at least we then know that we are not alone with those open questions. So with that introductory remarks, let me just introduce the first case study we have for you. I believe about a decade ago, Marks and Spencer tried to set shop and open stores all over the place in continental Europe, and a couple of years later, they had to realize that this does not really work. And now with Brexit behind and just having beaten the Germans in football in Wembley, they thought, hey, it's maybe good to give it another chance. And they decide to go back to continental Europe. And in preparation for that, we have a few employees, some of them executives, other of them normal employees, traveling to our respective countries and cities to do different activities over here, and I'll be walking you over the things that they be doing here so that we can have a little discussion. And firstly, to start with, I would like to ask and invite Barbara to tell us a little bit about what has changed effective 1st of January with regard to the question whether UK nationals coming over to continental Europe would require a visa or not. And maybe you can just set the scene for that. And in the meantime, Laura, I think you can stop screen sharing so that we can see Barbara. Not sure, Barbara, are you with us? I haven't checked if she's there.
Sorry, I was there. I was speaking while I was still muted. Sorry about that.
No problem at all. Welcome. Welcome back. Your first day after vacation. A special shout out goes to Barbara for that.
Very tanned. My name is Barbara Wegelin. I'm a lawyer in Amsterdam, and thanks for having me on this panel. I was a bit daunted when I saw the whole audience, because I thought, wow, the collective know-how that we're going to have in the room will far exceed my knowledge, and that is in a large part attributable to the fact that there are certainly lots of things that we are still working out as practitioners, and not just as practitioners, but also the immigration authorities who we are dealing with. We're finding that in general, we're sort of working our way through muddy waters when it comes to finding out what is permissible and what is not permissible. But what we're certainly seeing, and it sort of echoes what Hugo was saying, is that after the 1st of January, there was this sudden realization for British clients, companies, oh my gosh, now we're going to have to deal with 27 different sets of immigration laws, because there's no harmonized immigration law. And that came as sort of a shock, which has been somewhat delayed and cushioned, obviously, by COVID. Obviously, we had We had the withdrawal agreement before the 1st of January, which I won't speak too much about because that's not where most problems are, as far as I know. At least they are not in my jurisdiction, because the Dutch Immigration Department has chosen to implement the withdrawal agreement in a very sort of loyal way. Practically all my clients who have requested a document on the basis of the withdrawal agreement were granted one. So the issues that we're facing are more with the people or the companies or the clients who were not covered by the withdrawal agreement. And the only guidance that we have is obviously the trade and cooperation agreement that was signed between the UK and the EU. If you look at that document, it's sort of boggling and very easy to get lost in the, I constantly have to go back and check how many pages it is exactly, but 1,246 pages, of which only a small part, gladly, is relevant for immigration practice. And I say gladly because it helps not to have to go through 1,246 pages, obviously. But when you're looking for very concrete guidance in a specific case, or you're dealing with a situation that raises very specific questions, you'd rather have more than less guidance, obviously. And SERVIN, which is the relevant part of the trade and cooperation agreement, is concise. What the relevant part of the trade and cooperation agreement is for us is we need to look at Part 2, Title 2, Chapter 4, which is, and now I have to go back and look at the exact wording. It's the abbreviation is SERVIN, and I think it's services, and I always have to go back and check what it actually says. Help me out, Gunther. Here we go. Title 2, services and investments. If you look at the categories of people, of business people who are covered by SERVIN, we've got the what I'll call the intra-corporate transferees. We've got business visitors who are coming to incorporate a business or establish a business in one of the member states. We've got service providers on a contractual basis. We've got short-term business visitors, and we've got the free, I always have to translate back from the Dutch to the English, the free professionals, or who I just call the business people. And I think what's interesting when you're looking at, because Gunther asked me, can I say something about the short-term business visitors, that's specified in Article 4.3 of SERVIN itself. If I look at that article from the Dutch perspective, what's interesting is that SERVIN is actually, Article 4.3 of SERVIN is more, provides more rights and more possibilities for British contractors and business visitors than the existing Dutch immigration regulation allows. For example, we've got a 90-day cap out of 6 months for short-term business visitors, when in the current Dutch immigration regulation, we've got a maximum of 13 weeks per 52 weeks. So that's actually a better deal as it is. What's also interesting is that the existing Dutch framework allows short-term business visitors to come here and have business meetings. When you look at the list of things that the Trade and Cooperation Agreement considers to cover short-term business visits, it's much more than just engaging in corporate meetings. For example, we've got marketing and sales. We've got translation and interpretation. And what's also interesting is that it's not necessary, as far as I can see, that a short-term business visitor is an employee. The way I read it, it could also be a contractor or a self-employed person.
Thank you very much, Barbara. And just coming back to our hypothetical, I understand from what you have explained to us that the CEO and the two of his senior executives could easily come over, do some talks with the real estate agents over here, and maybe also conduct negotiations with their potential contractual partners, as long as that is not going to last more than 90 days. And they wouldn't even require a visa for that, because provided that there's reciprocity, the UK nationals would now also benefit from the so-called EU visa waiver program, which is now based on the EU trade agreement.
That's
which is
entirely correct, Gunther.
Thank you. Which is, by the way, indeed super long. If someone could drop a link to the actual agreement into the chat function whilst I'm speaking, that would be superb. And if you look at the agreement, there are provisions in Article 142 dealing with the short-term business visitors. And that is where the activities Barbara so nicely described to us are covered. And it's indeed a wider range than under various national business visitor categories. But the business visitor category in itself is not properly and 100% described in it. And maybe, Bernard, if I may ask you to take up on that question, knowing from memory, or I believe to remember, that the Belgian authorities have at least made an effort to give a little bit of a description of what may be interpreted when reading business visitors. Can you just add on a little to what Barbara has explained to us, if I may ask you?
Of course. Thank you, Gunther. Hi, everyone. So with regard to business visitors, what Gunther told us is completely right, but actually this was an effort that was already made by the Belgian authorities prior to Brexit, prior to the existence of this trade agreement, in the sense that under the existing Belgian corporate immigration laws, there is a work permit exemption for all third country nationals who come to Belgium for what is, the legal wording is meetings in closed circle. And there is no, let's say, formal definition of this wording, meetings in closed circle, but from conversations that we had with the authorities involved, like, for instance, the National Social Security Office, as well as the regional authorities that handle business immigration applications. It is clear that this actually refers to meetings during which one does not provide regular work. One of the examples that was given to me by one of the leading civil servants of the National Social Security Office, for example, if you have an auditor who comes to Belgium for a meeting, even if it is a meeting in closed circle, so with a limited number of people, but he or she is doing audit work, the exemption does not apply because he or she is doing regular work. If, on the other hand, the auditor is in Belgium to negotiate a contract with a client for future work during that meeting, then the exemption can apply. So, like I said, it's not a formal definition. It's more something that's how it is applied in practice. This being said, what do we have now in addition to this existing exemption thanks to Brexit? Barbara mentioned the short-term business visitors clause in the trade agreement, and all regional authorities who handle the business immigration applications in Belgium, being the Brussels, Flanders, and Wallonia authorities, they have explicitly confirmed that insofar as the activities that are listed in the trade agreement, that's Annex 21, if I'm not mistaken, are all the activities that are allowed for short-term business visitors under the trade agreement. Insofar as these activities are not yet envisaged by the Belgian legislation as exempt, as work permit exempt, the authorities will consider all those activities that are mentioned in Annex 21 as work permit exempt. So that's the very clear position there, that this article, I think it's now 142, and Annex 21 are fully applied by the Belgian authorities. So if you check Annex 21, and if you see that a UK employee is eligible for, well, if the activities are listed under this, under the activities mentioned in Annex 21, you can invoke a work permit exemption in Belgium.
Thank you very much, Bernard. Let me just pick up a question I have just seen in the chat function from Stephen Walker, who says, I'm a British national who owns a small business in both London and Berlin, where he's registered with the local registry office, and he's wondering whether he may just travel to Berlin like he did before, and is asking more specifically whether the 90-day rule would apply. And the answer to the question here is, firstly, with regard to the 90-day rule, you wouldn't require a visa if you come as a business visitor for up to 90 days within any 180 days. So that rule would apply, but only if you limit yourself to activities that are covered under the trade agreement. And like Bernard just explained, you then have to see whether you can fit yourself into the business visitor category. And given that you have businesses both in the UK and in Germany, I would assume that your stays are linked to your business over here. And with that, it would be possible for you to come and do what you would like to do in Berlin. Stefan, coming back to our hypothetical, the guys who shall set up the limited on behalf of Marks and Spencer Reloaded company, could they do that in Paris? And would they need a work permit for such activities? Can you give us a little bit of the French perspective maybe on that?
Well, not only they could do that in Paris, but I think they should. There's one point I would like to make following what Barbara mentioned earlier. I think for those who are not familiar with the trade and cooperation agreement that is to govern the future relationships between the UK and the I was going to say the EU, but actually the TC is structured so as to govern the relationships between the UK and each individual EU member state. It's one signed document that actually involves 27. If you had the Brexit, if you had the UK, 28 individual perspectives and needs. The TC is structured so as to agree that all liberalized services that are included in its scope are fully liberalized, but it is then subject to long lists of exceptions, some very broad, set out in extensive, highly technical annexes, which vary between each EU member state. It adopts, and for me that's a change in paradigm and in the way we have to see the future. The current and future relationship with the UK. The TC adopts a mix of positive and negative listings and includes a list of expressly permitted activities that can be performed without the need to obtain a work permit or submit any form of economic needs test or other pre-approval procedure. The TC provisions override the current national immigration legislation in the member states, except where a specific EU country indicated reservations. So the agreement itself, as Barbara mentioned, is over 1,300 page long. The annexes themselves are over 200 page long. So the agreement, the TCA widens the list of sectors and exemptions, which provide for a more transparent list of rights. But by setting out lists of limited cases, any situation outside of those lists will fall under the standard requirement for a work permit, and, as the case may be, require a prior labor market test. And part of that change in paradigm, henceforth, it is the nature of the activity that is more, or that will be more decisive than the length of time of the contemplated stay. So, going back to the case study, the hypothetical, and the setting up of a company in an EU member state, for example, France. Yes, I believe that the situation could fall under the one of the categories that are listed in the chapter 4 that was mentioned by Barbara. And it relates to business visitors for establishment purposes. So the investors could come over for up to 90 days, no more, provided that they hold a senior position in the UK-based company, and they can evidence that they are responsible for setting up the entity in France, but that must not provide any services in France or engage in any other activity while doing everything that is necessary to organize the setting up of the company, and they cannot be paid from a French source. But as far as this is concerned, this is not very much different as what existed before. So the short answer to your question is yes, they could and they should, and that's easy.
Thank you, Stefan. And I will be coming back to you later for the long-term ones, because I understand that you have a slight preference for them setting up their foot again in France. Stefan mentioned a very important point. I mean, payment in the host country is always leading to a situation where the short-term business visitor category would end to be applicable. So you have to be sure that your employees or yourself, when you're assigned to Germany, France, or elsewhere in continental Europe, keep on being paid by the UK company. Otherwise, it wouldn't work. Finally, let's also talk about those that shall be staying for longer. In my example, I have chosen some UK nationals that shall stay in Germany, France, and the other countries for a few months, and some of them shall even stay for maybe up to 3 years. What can we do with them, knowing that in the past there was never a problem for UK nationals coming to another member state and work there? But in the meantime, a UK national, in principle, is a third country national. So here the question is, what are the privileges left? Like I suggested to Laura earlier. Barbara, what could we do if they would really like to work for not only a few weeks, but a few months or even a couple of years? Any chances to do so in the Netherlands?
Certainly, there are chances. One of the interesting things in the Netherlands is the Netherlands. I don't actually know if this is the case for Germany and France as well, but the Netherlands has interpreted the Vienna Treaty on treaty obligations in a way that there is this sort of most preferred or preferential treatment possibility. And right now, I and a lot of my colleagues are looking at a very, very old tractate of trade and shipping between the Netherlands and the UK from 1837, trying to figure out whether or not there are absolutely no migration provisions in this document from 1837, but whether or not we can't distill something that makes it look as if UK citizens would not have a preferential position vis-a-vis what we call third country nationals based on this tractate. The answer to your question, Gunther, is if they would want to stay for longer than those 90 days that we've been talking about, then you're going to have to look at the Dutch national immigration corporate immigration scheme that exists. And obviously, the easiest way for a third country national to be allowed to be here in relation to work is the highly skilled migrant scheme, which is very similar, I think, to what exists in Belgium and in Germany and in France as well. You've obviously got the intercorporate transfer directive, which also plays a role in a hypothetical like the one you've described. So you could use maybe that as a basis as well. But the trouble for our clients is going to be, what if they're going to be doing business not just for 90 days, but for longer, as you say, but in different member states? Does that mean that they're going to need national work permits in different member states? And that's, I think that's coming up to the most tricky part of the post-Brexit corporate immigration world.
Yeah, that's a very good point indeed, because the national visa or work permit does usually only cover the country of destination. And in our hypothetical, if those guys would like to travel from Paris to Amsterdam and then on to Brussels and Cologne, they would need to speak to 4 different councils to see whether the highly skilled migrant scheme really matches. And indeed, we have similar categories in store, but you need to have a closer look to each of them. And for instance, in Germany, we have one that requires only that you are properly paid and that what you do is legally permitted. So we have put the UK nationals in a very privileged store, but that may be different in other countries. Just a question I take up from the chat. In case of documentation, when you come to continental Europe as a UK national, be it for business or be it for a proper application, what, if I may pick up you on that, Bernard, would you recommend to use as a proof for being a short-term business traveler? And then second, Stefan, maybe you can talk a little about the documentation we would require for a proper work permit application.
So when it comes to, let's say, proving the purpose of the business trip for Belgium, we can always, well, the idea is that if you invoke a work permit exemption or professional card exemption, which is like, professional card is like a work permit, but then for self-employed, the idea is that you prove it yourself if requested. So if there would be an audit, if someone at the border asks you, if there would be an audit by labor inspection, you need to be able to submit some documentation in order to prove that you can invoke an exemption. And luckily for us, there is still an old legal text, which is like, I think it's dated 2007, where for most work permit exemptions, at least, there is a list of proof that is considered sufficient at first hand, in the sense that it is the minimal proof that is required, that you have to bring with you, but the authorities always have the right to, let's say, to overrule this and ask additional documentation, or if they esteem that the facts are not compliant with the information that's provided, and they can always overrule this. But it's like a list of the minimal evidence required. And for instance, if we look at the category I mentioned earlier, the meetings in closed circle, which is basically the general business trip, there the proof that's required is a sworn statement by the employer in which you explain what the employee is going to do in Belgium. So basically, employer X, I sent employee Y to Belgium for X number of days. The purpose of the trip will be meetings at the premises of, I don't know what, client or etc. And so you need to make sure in this statement that all requirements and elaborate on the fact that all requirements for the exemption are met. So that's the first tip I can give you. Always look at the minimal evidence that's required.
Yeah, thank you. And a good and hot tip is always to check also the official websites, such as German missions abroad have fantastic information available. Also for those being interested in returning post-lockdown, there was another question in the chat, so you may want to have a look there. Stefan, is that documentation even more complex in a work permit application scenario?
Well, yes, a little bit. We have a long tradition of administrative concerns in France. So you need to get quite a long list of documents, including an administrative form that is to be signed by the home company and the host company, a copy of the labor contract, a copy of the passport, of course, a copy of the resume, a copy of the degree, the host company also has to provide for an affidavit from the social contribution authorities showing that they are not indebted and everything is fine. Of note, for British applicants, now the documentation needs to be translated in English. It doesn't have to be a sworn translation. Although it is on paper required by the authorities, but it takes time, and that has to do with anticipating. You know, I think until last year or until 2 years ago, British nationals thought, and that was true. You know, they could decide to travel overnight and be in a plane the day after. It's not true anymore. If they are here for other, if they come over to Europe, at least to France, for other purposes than just holidays or a short-term tourist visit.
Thank you. Yeah, traveling within Europe is so much more complex and complicated, not only because of COVID, but because of all that. Doesn't surprise me, by the way, that you require proper French translations. Let us maybe take a hold here and move directions and pass over to Laura to look into the problems for companies wanting to come to the UK and now also realizing that the UK is no longer just another member state. So maybe Laura, would you like to take over?
Thank you, Gunther. Yeah, I'm going to speak on the consequences of Brexit for EU nationals, and I'm doing this from the City of London. As Anne-Marie Martin said earlier, we have sunshine and rain at the same time. Well, like other countries, we have some uncertainties and we have some certainties. But sadly, one of the certainties is that EU nationals without EUSS settlement status or pre-settled status will be treated as third country nationals. Gunther, as you said, the Brits will be in your fine countries. So many people, we did run a successful EUSS, EU settlement status program where the Home Office had an app that was very easy to use. It was free of charge and it was quick. And we had about 5 million applications, but there were still lots of EU nationals out there who have not applied. And of course, for obvious reasons, we don't know the numbers, but there has been a great campaign in the UK, which my firm were involved in, called Here for Good, where we went around the country promoting EU nationals to make an application. So if in our hypothetical, our consultancy company wants to continue to employ the EU nationals that they have in the past, we need to make sure that they have applied successfully under the EUSS settlement program, and they either have settled status or pre-settled status, so the employer would be able to continue to employ them. If we can't forget, if they haven't, there is also still the possibility of the frontier workers, which we were all speaking about and laughing about a few months ago, but that is still a possibility for people who have been working in the UK, but primarily living abroad. And it may well be that they can apply for that. If that isn't applicable, if neither EUSS or frontier work is applicable, then they have to look at the categories under our immigration rules, like you all have perhaps an intercompany transfer if they're working for the company abroad and they've been transferred into the UK. The UK employer would need to have a sponsored license application and issue a certificate of sponsorship to the EU national. There's general requirement of £41,500 to take the employment, but they will not be able to apply for permanent status in the UK. They should, if possible, apply under the skilled worker route, which has a low threshold, no resident labour market test, and it may be that they can apply under that and then obtain permission to work in the UK, and under that it's possible to get permanent residence. We have, in the past, we've all discussed that we've got very similar business visitors rules. So like Brits coming into your country, or third country nationals coming into your countries, in the UK, we allow people to come in for business visitors. They can do very similar things to your country's permit, and they're prohibited from doing similar things, but they can come into the UK for up to 6 months, but they must not be working, but they can carry out particular services. One of the questions was about UK dual nationals, and we can't forget that those who are dual nationals, EU and UK, they're in a very beneficial position because they're entitled to work in the UK under the UK nationality or Irish nationality, and in the EU under their EU nationality. Of course, an additional way to enter the UK is either as the spouse of a partner of a British citizen. So at the moment, I'm no longer a EU national, but I'm looking forward to Scotland getting its independence, joining the EU market, and then I can happily apply for my Scottish passport.
Yeah, that sounds like a good solution at the midterm, of course. Thank you, Laura, very much for that overview. And here again, when we come to the UK, no need for a passport, so that is okay for up to 90 days. But if it comes to what we will be actually doing, we have to take a closer look and would have to double check whether coming over as an intern would be permitted, whether post-sales service would be covered. And it may be different from what we have experienced in our countries. What are the day-to-day queries you're getting from your clients that would like to go and come into the UK? What are their challenges at the moment?
Well, a bit like Europe, there's lots of uncertainty, and people, some even sophisticated businesses are often a little bit naive in assuming that people can remain working in the UK, or they've been here previously. But we have been training our clients over the months to make sure that the EU SS applications have been made successfully, as that the scheme has actually been successful. But there, again, the questions about what they can come and do as business visitors, how long they can stay, can they switch into permission whilst they're here? And there's lots of questions about our clients who have got British nationals going out to your various countries. And I think it was Barbara who said that you think that the Brits can think that they can come out and work in your countries, just showing their passport, you know, rocking up at immigration and coming in and working during the 90 days. They don't appreciate the difference between a visitor, the activities they can do, and those that they cannot do.
Well, thank you. And when it comes to compliance, let us talk a little bit about compliance. I mean, in Germany, immigration law compliance has never been a serious issue. And that has not really changed, but in the last years, at least some companies are getting audited and stuff like that. That has never been the case for US nationals, Australian nationals, our business friends. And I hope that that is going to be the same for the UK. But I've heard in one of the introductory remarks that people have been stopped at the frontier, have been questioned. Another question from the chat was whether I will be having problems when traveling via the Netherlands to Belgium and the other way around as a UK national. And in the UK, do you have the impression that immigration law compliance for EU nationals is going to get a bigger issue because of Brexit?
Well, immigration compliance in the UK, Gunther, unlike in Germany, has been very serious for a number of years, and the Home Office take it very seriously if somebody, an employer is employing people without having a sponsored license, or they have got a sponsored license from the Home Office, but they're breaching conditions under it, they're not monitoring employees and documentations. And we deal with a lot of threats from the Home Office to withdraw employer sponsored license applications. We're usually pretty good at overturning it, but they do take it seriously. One of my clients was a restaurant client in Soho was raided by the Home Office, and it was late on in the afternoon, and one of the staff was actually arrested. They thought that he was a customer when actually he had permission to work in the restaurant. The Home Office were threatening to withdraw the sponsored license, and my client was saying he had a really bad day because not only would he have to incur legal fees to overturn this, but the client who had been arrested, or the customer who had been arrested, hadn't paid his bill.
Oh my God, yeah, but immigration law compliance is indeed a little more serious in your country than in mine. Maybe not so much different from the Netherlands. They have a tradition in being a bit stricter also on that here. Would you also like to talk a little about your hypothetical case and maybe just pick a little bit of it for the discussion? We have something like 7 to 10 minutes left, so maybe not too long.
I've gone over much of it from the. I kind of went quickly rather than go into the hypothetical in great detail. But the issues for employers is to look to see if the EU nationals who have got the EUSS, pre-settled status or settled status, and if they have settled status, they can remain in the UK for 5 continuous years and continue, and they'll be able to come into the UK to work, even just touching down to do work, or come in as a business visitor. The pre-settled status is where somebody hasn't had 5 years in the UK, and they'll get pre-settled status, but when they come up to the 5 years, they will be able to settle. They would lose their pre-settled status if they left for more than 2 years. And then for potential hires, which we have in the case study, you have to look at the various options that are available from them. As I said, our skilled worker is actually quite welcoming entry clearance, because there's a lower threshold than previously, and we got rid of the resident labour market test, which caused a lot of problems and expenses and was time consuming for employers. The drawback in the UK is our sponsored license system is pretty expensive for employers, and each time they issue a certificate of sponsorship, it's nearly £200. There's an immigration skills charge of £1,000 per year of sponsorship for larger companies, and we have a Home Office application filing fee of over £700, and if that's out of the country, if it's in country, it's nearly it's over £1,400. So it's very expensive to come to the UK. We also have an immigration surcharge. So although it's expensive, it is still worth coming from. We would make you very welcome.
Of course. And by the way, that does not even cover the costs for immigration counsel. So that makes it even more expensive, probably.
Sorry, can I ask Stefan a question, Gunther?
Of course.
Sorry.
Yeah, sure.
Stefan, so as a British national, what if I wanted to come and work if I was lucky enough to have a home in Paris, be a neighbour of yours, would I be able to do so if I was on the UK payroll? Could I just rock up in France and start working?
Oh, you would be more than welcome. Would that be because you don't want to be on a French employment contract? Yeah, but I mean, only someone very eccentric, completely misinformed, or helplessly workaholic would voice the opinion that being under a French employment contract is not a good thing. The answer is yes, it is possible for you to undertake remote working while being resident not only in France but in Paris, nearby where we all live. However, for those British nationals settled in France before the end of December 2020 and who were issued with a withdrawal agreement card, they can work without a separate work permit, provided that their UK employer completes a registration with the French Social Security authorities. So there would be some administrative steps to be taken by your firm, Laura. And both the employee and the employer are then subject to payment of French Social Security contributions, which you may not like. If you are outside of the withdrawal agreement provisions, then you will need to have a prior work permission subject to a prior labor market test taking the form of previous advertisement of the position during at least 3 weeks. But no doubt that nobody could take your position, nobody could replace you. There's only you who could do that. And also you will need proof of registration of your firm in France with the company's house. And if the work permit is granted, then a visa residence permit on top of the above. Of note, even if you remain under a UK employment contract, the core labor law rules are imperative and they will apply. That will include a minimum salary and French working time regulations, which I think you can find to your advantage.
Thank you, Stefan. Maybe just Bernard and Barbara, a few words to close with a little bit of an outlook or a hot tip to take away.
Just following on Laura and Stefan's discussion, it's one thing to be operating on the assumption that Laura is or is not going to be covered by a very generous French employment agreement or a not so generous British employment agreement. But what if Laura is, self-employed? What if there is no employment agreement? And then, we'd be touching on this really interesting category of independent professionals in the trade and cooperation agreement, which could provide us with a lot of leeway. But in terms of the uncertainties that we've all highlighted, I myself, for example, haven't really dealt with the independent professional category yet, in terms of having to discuss how far does that go, what does it allow someone to do with the Dutch immigration authorities. In terms of an outlook, I think the proof of the pudding in terms of the trade and cooperation agreement is going to be in the eating of it in the post-COVID arrival of lots of British workers, especially being mindful of the fact that traditionally British companies tend to work with contractors who are not on an employment agreement. And just going to see how that ball is being taken up by the various immigration jurisdictions. But I do feel, very unfortunately, that it is inevitable that British companies are going to have to seek counsel in various member states, because we don't have a one-size-fits-all for Germany, France, Belgium, and the Netherlands. It's going to be 4 separate sort of pieces of advice, and that might be good news for lawyers, but it's obviously not good news for business.
If I may elaborate a bit on that, I have experience with France, with the UK, with Netherlands, with Poland after Brexit. Self-employed, getting them to France is a bit difficult because, like Stefan already said, you need pension, tax, social security, health insurance, and a lot of these guys don't fulfill all the 4 conditions. So we sent them home. In the Netherlands, it is much more related to immigration and getting a work permit for them. And then you have the issue that you have to prove that you can't find a person in all of Europe that can't do that job. And that's for self-employed as well as other people coming in. Poland is a bit easier, and for me the UK is so far, funny enough, the most easiest country to get employees into.
That's a very good takeaway. I'm pleased to hear.
Earning model there, but it's doable.
Can I just volley that back to you, Geert? The test that you're talking about in the Netherlands, where you have to show that no one else from within the EU would be able to do that job, for the contractual service suppliers, that requirement is waived for the first 12 months.
Okay. So, but you still have to get a work permit for them.
Well, and you would get the work permit on the basis of the trade and cooperation agreement.
Yeah, I know that. I didn't know. We didn't encounter it.
So at least we have one practical issue solved.
Yeah.
Yeah, what we really have to do is to join our efforts, council, companies, and of course, trade organizations, to get as much out as possible of the trade agreement. And rather, that is my tip to take away, rather than to put questions to them, seek confirmation of our understanding that actually what we would like to achieve is permitted. But maybe we have other people who would like to say something, or shall we call it a day, Ilka, with a view to the watch, of course.
Can I make 3 short remarks? Very short, very briefly.
Yes, of course, Bernard.
So first of all, we've been discussing the trade agreement, but there's also the withdrawal agreement. And it's not too late in Belgium to invoke your right as a beneficiary of the withdrawal agreement. So actually the application period for those who are considered a beneficiary of the withdrawal agreement, UK nationals and their family members, they can apply for a residence permit until the end of 2021. So it's a full year. So that's one option you have to look at. UK nationals who resided in Belgium before the end of 2020, they have a full year to apply for their permit as beneficiary of the withdrawal agreement. Secondly, if UK nationals, if you're looking to obtain an authorization to work, one of the things that you always have to keep in mind is that a frontier work permit can be applied for. The advantage there is that you don't have to take up residence in Belgium, and it can be valid for up to 1 year, and it's renewable. Another advantage is less documentation, less administrative work. And the third thing, very briefly, something that's also mentioned in the trade agreement, the definition of contractual service suppliers. It there says that employees who are employed by means of supply services of personnel or agencies for placement are excluded. And I would just like to point out that under Belgian law, this can be a very difficult issue as well. We see in practice that a lot of UK companies who send people to Belgium it's not their own personnel, but it's staff that's hired through an agency for placement. And you always have to draft your contracts for services in Belgium very carefully, because in Belgium there's a principle that you cannot lend out personnel to a third party. You cannot just transfer the authority over an employee to a third party. There are exceptions, but that's a very important principle. You have to take that into account and draft the contracts very carefully and make sure what kind of instructions can be given by the third party to the employees. That's it. Thank you.
Okay, thank you very much. I want to look at Hugo. You have a final word for us to sum up?
Thank you. Yes, indeed. So I actually found the whole conversation here very, very interesting indeed. And it's been interesting to hear what people are looking at to pull together when it comes to different rules or different legislation. So we can look at the withdrawal agreement. There's things in the trade and cooperation agreement. There's of course current national legislation. We're even going back to treaties going back to 1837. So there's a lot going on, and I think yes, there's change, but there's obviously also a reason for optimism because there will be specific ways out for different situations. And I think I'll leave it at that because I don't think I can add much more than what the experts have already very kindly discussed here today.
So there's room for optimism. I think this is a great final word. I want to thank our expert. I think that was a great session, and thank you to my colleagues from the Chamber of the Netherlands, to the Belgium and the BCC in the UK. I think it's worth joining things if it comes to such important topics and to share the experts that we have. Thank you to Mr. Mevers and his team, Laura and your colleagues. It was marvelous. And let's continue sharing high potential information we have on topics just to make the difficulties of Brexit a little less harmful as they are. Thank you very much, and enjoy the day. And